Guardian is also joining us.
Oh, thank you. Yes, thank you, sir, and welcome, ma'am. There we go. All right, so I think we've got a couple issues here today. Number one, we're here today for a final pretrial conference. Number two, because I've been handed an advice of rights, I anticipate there's going to be a resolution by an entrance of a plea. And well, we already did the I'm sorry, we already covered the Department of Health and Human Services report. Am I correct?
Correct.
Yeah. All right, thank you. And we're going to note here that that was a review that this court ordered for criminal responsibility, and that came back, and that the defendant did not, quote, have an intellectual disability or mental illness as defined by the statute. All right, thank you very much. And Ms. Carey, why don't you go and tell me what the terms are of the agreement today?
Thank you. It's my understanding that the defendant will plead no contest to count one, UDAA. Count two, failure to report an accident to fixtures. The people will dismiss counts 3, 4, 5, and 6. He will plead no contest to an added count 7, home invasion 3rd degree. Added count 8, attempt, resist, and obstruct a police officer, and added count 9, operating a vehicle while visibly impaired. And I do have the reports.
You said that home invasion was a 3rd, or what wasn't an attempt, was it? Just a 3rd? Now, for that home invasion 3rd, is it going to be considered as a lesser included of the home invasion 1st?
Correct.
We're asking that, Mr. Hartel, is because when it comes to home invasion 3rd, there are a variety of specific ways to be guilty of that. Is that so? Do you agree?
I would concur that that's the best way to do it. Yes, Your Honor.
All right. Do we have a police report?
Yes, I'm marking it right now.
All right. I'll wait for Nancy to go ahead and do so.
And there are 2 reports and 2 red reports.
Thank you. All right, I now have those reports, and we're going to put those in the record here in just a moment. All right, Mr. Failer, have you heard what we've just talked about?
Yes, Your Honor.
Now, before this, coming here today, did you have the time to meet with Mr. Hartel about it?
Yes, Your Honor.
And when you met with him, did you have your guardian with you, or?
No, Honor.
All right, ma'am, what's your name?
I'm Lee Storage.
Please spell for us both names.
LEESTORCH.
All right, Storch. All right, thank you. And Ms. Storch, you're appointed by a court to be his guardian, is that right?
Yes, Wexford County.
All right, good enough, thank you. And that would be before Judge Edward Van Alst.
Yes, sir.
Great. Thank you very much. Now, have you had the opportunity to speak with Mr. Failer about this?
No, but his attorney has called
Okay.
and talked to me and Ed.
All right. Mr. Failer, do you wish to speak with Ms. Storch about this before we continue, or do you think Mr. Hartel has explained it to you well?
He was explaining it. No.
All right, good enough. Thank you. All right, Mr. Failer, please raise your left hand. I'm sorry, I said left, and you did your left. I meant your right. I did it wrong. Mark that down. I think that's the first time I've done it wrong. All right, sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thanks. You may lower your hand. All right. Mr. Failer, we're going to go through this, and if at any time you have any questions, all you got to do is let me know, okay?
Yes, Your Honor.
All right. Now, you are currently charged, or it's alleged here on this piece of paper that you've committed 6 offenses. Now, some of those I expect you're gonna plead guilty to, and then some of them are gonna be dismissed. But to get those dismissals, you're gonna plead guilty to some other charges. I said guilty, it's gonna be a no contest. Let's talk a little bit about that word, no contest. When someone pleads guilty to an offense in a courtroom, they have to tell me what happened. Right? They have to admit. So for instance, if there's a charge of possession of a drug, they have to say, yes, Judge, I had that drug. I knew I had it and I knew what it was. Okay? They can't come in and say, well, Judge, I didn't really possess it. It wasn't really mine, but I'm pleading guilty just to get this thing over with. That doesn't happen here in this courtroom. Do you understand?
Yes, Your Honor.
All right, so now instead of a guilty plea today, I'm told we're gonna do what's called a no contest. Now, a no contest means that instead of you telling me what happened, I'm gonna read something such as a police report. And whatever's in that report, I get to consider as true. Do you understand that?
Yes, Your Honor.
Now, did you talk about this no contest plea with Mr. Hartel before coming in here today?
Yes, Your Honor.
All right, good. Was he able to answer any of your questions?
Yes, Your Honor.
Great. Now, when it comes to that report, I get to consider whatever's in there, and I just told you I get to consider it as true. Now, here's what's also really important. Sometimes, even though I have this conversation that I'm having with you, with other people, they forget it. And they'll come back and try to argue that whatever's in that report isn't true. So I need you to understand that when you enter a plea of no contest, whatever is in here, you can't come back and say, well, Judge, it's not true. Do you understand that?
No.
All right, good enough. Thank you. Now, let's talk about what the charges are. You are currently charged with, again, 6 counts. Count 1 is a charge of unlawful driving away of a motor vehicle, which means you allegedly took someone's vehicle. Apparently, it's something called a Chevrolet Track without that person's permission, and you drove it away. That's a felony punishable by up to 5 years, plus the Secretary of State would suspend your driver's license if you have one. Now, that's an offense I'm told you're going to plead no contest to. Count 2 is a charge of failure to report an accident to fixtures. Let me explain what that means. That means that apparently you drove this Chevrolet Track, hit something such as a sign. And this one apparently is the Cadillac Public School electric sign. And then you drove away without reporting it to police. Now, that's a misdemeanor punishable by up to 90 days and or $100. That one I'm told you're pleading no contest to as well. Count 3 is a charge of what's called home invasion in the first degree. Now, that's a felony punishable by up to 20 years and or up to $5,000. Plus, there could even be something called consecutive sentencing. That's really important. Let's say that I gave you, and I'm just using round number, just easy numbers. Let's say I gave you 1 year for unlawful driving away of a motor vehicle. And if you went to trial and you were found guilty of the home invasion first, and if I gave you 5 years for that, so it's 1 year for the first count, 5 years, the consecutive means you'd have to serve 6 years total. But that's not going to happen here today if this plea goes through. All right. So count 3, home invasion first, I anticipate is going to be dismissed. Count 4 is a charge of unlawful driving away. This is another charge, which is a felony punishable by up to 5 years and license suspensions by the Secretary of State. And apparently, this is another Chevrolet Track. This one's owned by another person, but that count's going to be dismissed.
That might be a typo.
All right, well,
Yes, Your Honor, the typo.
okay, no problem. That's all right. I'll tell you what, it doesn't really matter as whose name it is because that count will be dismissed. Okay. Count 5 is a count of driving and operating a vehicle while intoxicated. That's a misdemeanor punishable by up to 93 days and or a minimum of 100 to a maximum of $500 in fines and or 360 hours of community service, rehabilitative programming, possible vehicle immobilization if you have prior drinking and driving, plus you could be assessed the cost of prosecution and reimbursement to the government for any emergency responses. Plus, the Secretary of State would take or add sanctions against your license. That doesn't happen in the court, but it could happen or would happen with the Secretary of State. Well, that count's going to be dismissed. Now, count 6 is a charge of assaulting, resisting, obstructing, or endangering a police officer. Now, that's a felony punishable by up to 2 years and or up to $2,000. That charge will be dismissed. So we've gone through those 6 charges as they appear today. You're pleading no contest to 2 of them, and 4 will be dismissed. But there's going to be 3 additional charges that you're going to plead no contest to. Added count 7 would be a charge of home invasion in the 3rd degree. So instead of home invasion first, which is punishable by up to 20 years, a home invasion in the 3rd degree is punishable by not more than 5 years, in other words, up to 5 years, and or up to a $2,000 fine. All right. So it's a lot less than 20 years. Then you'd also be pleading no contest to added count 8 of attempted assault, resist, obstruct a police officer. So where I told you earlier that assault with intent, assaulting or resisting a police officer was a felony punishable by 2 years. By making it an attempt, it reduces the maximum punishment down from a felony to a misdemeanor and from up to 2 years down to 1 year. And instead of $2,000 in fines, it's $1,000 in fines. Any questions thus far?
No, Your Honor.
All right. Now, the last count to which you're going to plead no contest to is an added count 9 of operating while visibly impaired. That's a lesser charge than operating while intoxicated. It's still a misdemeanor. It's still punishable by up to 93 days. However, it has some other limitations. Is it $300 or $5? We don't get too many visibly impaired up here. I think it is up to $300, and the Secretary of State will also take other sanctions against your license. Do you have any questions, Mr. Baylor, about all those charges?
No, Your Honor.
Now, again, I'm going to ask you this question, but I'm also going to ask you it again later. Have you talked to Mr. Hartel about this plea?
Yes, Your Honor.
And has he been able to answer all your questions?
Yes, Your Honor.
And have you been able to understand them?
Yes, Your Honor.
All right. Do you have any questions for me at this time so far?
No, Your Honor.
Are you satisfied with Mr. Hartel's representation and with you?
Yes.
All right, good. Now, if you enter this plea of no contest, you're not going to have a trial of any kind. Does that make sense?
Yes.
Now, Mr. Hartel did the right thing today and provided me this piece of paper called advice of rights. Now, it looks like it has your signature at the bottom. Is that your signature? Can you see it?
Yes, that is mine.
Okay. Now, here's an important question. If you didn't read them or didn't understand them, that's okay. Did you read through all this?
Yes, Your Honor.
And were you able to read that language?
Yep.
And I'm not trying again to be insulting. I'm just asking to make sure. Do you understand that by pleading no contest today, you're going to waive all these rights?
Yes, Your Honor.
Okay. Do you have any questions about your rights today, sir?
No, Your Honor.
All right. Also, you're going to be given up the right to claim that today's plea was a result of any other promise, threat, or inducement not told to me today on the record. Has anyone made any other promises, threats to get you or force you to plead no contest today?
No, Your Honor.
Has anyone made any promise to you as to exactly what the sentence would be in this case?
No, Your Honor.
Now, Mr. Hartel probably talked about something called the Michigan Sentencing Guidelines. There are charts and things like that that tell judges, here's what we think as a legislator, what a sentence should be. I want to tell you that those guidelines are not mandatory. Also, it is up to me to determine what the sentence is. And at this time, I have no idea what I'm going to do for sentence. Do you understand that?
Yes,
And we're about to take a plea here in a second. Before I do, I want to ask one more time. Are you satisfied with Mr. Hartel's representation and consultation with you?
yes,
All right, do you need, or do you feel like you need it all to speak with your guardian about this before you enter your plea?
I would like to.
You would? That's perfectly okay. I'm not here to force anything today. We're gonna take just no, I don't know how long the break will be. We'll take a break and let Mr. Hartel and Ms. Storage talk about it with Mr. Failer. All right, thank you very much. We're in recess.